On this episode of Law Weekly, we discuss the labor crisis in Kaduna and other states. We have the views of senior legal practitioner GT Ogunye. Also showing on the program, the Attorney General of Lagos speaks about the activities of his ministry in the past 2 years, plus the launch of the state's gender-based violence event virtual referral and response service. Hello and welcome to the program. I'm Shola Sheyeli. The recent labor issues in Kaduna got very ugly, with the state governor declaring the NLC president wanted for sabotage and economic crimes. And that's the starting point of my conversation with senior legal practitioner GT Ogunye.
Now, Nigeria is supposed to be a democracy anchored on the rule of law and the constitution. And the constitution has set up the institution that determines civil disputes, and that's the judiciary. And part of that judiciary is the industrial arbitration process and the National Industrial Court. Yes, under our law, there's a provision for arbitration of trade disputes, for awards to be made, which will be binding, and for those who disagree with those awards to appeal further, National Industrial Court with the appellate process, and then get a binding decision. So make no mistake about it, our law has adequate provisions and avenues for resolutions of trade disputes and for the resolutions of this dispute to be binding on all the parties. Unfortunately, the executive branch of government at the state level and at the federal level, management generally in the public sector, usually are recalcitrant. And because they are recalcitrant, they foist a situation of semi-helplessness on the workers. I mean, the question would then be, who will enforce this judgment? Who will enforce these awards against the executive that is established by the Constitution to enforce judgments, to enforce the laws? That is the dilemma. But regardless of the fact that this dilemma is pervasive and prevalent, that doesn't mean that we don't have this. And strike is recognized as a legitimate and lawful weapon at the disposal of workers to push through their labor demands, their worker demands.
Now, the problems at the root of the labor crisis in Kaduna and other states are issues of mismanagement of scarce financial resources, overblown bureaucracy, and corruption. Do you agree with those who say that the governor is courageous for taking these steps?
Contrary to what the law dictates, the state government came up suddenly to say that it wanted to retrench workers. And it started with the campaign that the money being used by workers from the IGR of the state and from the statutory allocation to the state government from the federal purse is just too much, and that the workers are just a little fragment of the entire population, and that therefore it will be in the interest of Kaduna State to retrench those workers. That could be an aspiration. Is it legitimate? I don't think so. Certainly not lawful. Because these workers that the government, and I don't want to personalize it by saying the governor of Kaduna State was saying that it was going to yank off the public service, had their employment, having statutory flavor, meaning that once they enter the public service or the civil service, they have a guaranteed service year or service tenure, and that it's either they will retire when they clock 35 years in service or when they attain 60 years biological age. whichever is earlier. And so, under the public service rules and their conditions of service and all enabling laws, you just can't yank them off except they've committed offenses recognized by law and they are punished duly under the public service rules. It's not a matter of saying that, I've now realized that I'm broke as a state. I don't have money and all that. Even if that were applicable, to say that there's no money to pay and that you are declaring redundancy in the sector, where under the principle of first to come, last to go will apply, you still have to follow the due process. You still have to make a declaration to that effect. And so if there's a collective bargaining agreement or some sort of agreement, the workers will then negotiate this. But what happened was that the governor or the government woke up suddenly and said that they wanted to do this. And when the workers then kicked through a legitimate strike, in my view, as I've said, the governor embarked on saber rattling, making incendiary statements, threatening their national leader that they should not come to Kaduna State, that they will be dealt with severely if they showed up and all that. Assuming without conceding that the workers even embarked on the strike unlawfully or illegally. As a government that embodies legality, because when you're wielding an executive authority, you are an implementer of laws. You are the one to enforce the law. So will you then resort to illegality to confront the alleged illegality of the workers in embarking on the strike? No. You would declare a dispute, because either party can declare a trade dispute and then look towards the law, look to the law for redress, for adjudication of that dispute. The governor didn't do this, and I feel strongly that the governor didn't act right in that instance. I know that a lot of people have been talking about courage. The governor is a courageous person. Yes, the state are burdened by wages and pensions. They cannot pay. So money needs to be freed to be deployed to capital projects and all that. There is no courage here. Courage means that you have the capacity to bear a burden that is not easy, particularly if you are put in government to bear such a burden. The government talked about providing employment, talks about creating an enabling environment for employment to be generated. So do you do that by sacking workers, thereby ruining their lives and means of livelihood, and thereby ruining their families? That's not what a government does. A government elected under the Constitution, we provide that the security and welfare of the people shall be the primary purpose of government. And I'm referring section 14(2)(b) of the Constitution. So I don't think that the government of Kaduna State acted fairly, legally, and lawfully in this regard. And what we've been told now is that the two parties, after that fight, are now come up. A 10-man committee has been set up. So which should have happened in the first instance?
Now, sticking with issues of strike, state governors and the leadership of the Judiciary Staff Union of Nigeria, JUSUN, and the Parliamentary Staff Association of Nigeria, PASAN, have finally entered into agreement on the modalities and timelines for the commencement of full financial autonomy, which is the root crisis of this strike. According to the Minister of Labour and Employment, Dr. Chris Ngige, the governors have studied this document and they are in agreement with it. And by Monday or Tuesday, we will see a trigger of the Section B and D, which says governments of the respective states shall credit the accounts of the legislative and judicial arms of government with a pro rata amount due to each arms of government under the 2021 appropriation law. Now, do you think that this is a solution that will work?
Let's start with what the resolution, the term of that resolution that you just read out as stated. It states, if I heard you correctly, that the government of the respective state shall credit their accounts. That's what the Constitution provides. Section 121, subsection 3. That the amount standing to the credit of the judiciary, which shall be a charge on the Consolidated Revenue Fund of the state, because the states in the Federation have their Consolidated Revenue Funds, as well as the federal government that has its own Consolidated Revenue Fund. So this shall be a charge on the Consolidated Revenue Fund of the state, and this amount shall be deducted and then be given to the head of the judiciary of that state. The argument before now has been that the states were not complying with this. There've been litigation, there've been actions and all that. And in order to force the issue, let's have a general nationwide strike, shut down the courts to put pressure on the state or the federal government to do something. And people have been looking up to the federal government. Indeed, there have been a suggestion that based on Executive Order 10, that the Accountant General of the Federation should be mandated to deduct the money from the source, from the center, and then give this money directly to the state. That would be a violation of the Constitution. That would be a further drive of Nigeria on the unitary path, in which case the country will be broken into several administrative centers, fiscally speaking, that will be tied to the almighty center. So the center directly will be giving money to the parliament, it will be giving money to the judiciary, with its attendant implication for cohesion of governance within the state. In a federation, states are units. They enjoy semi-autonomy within their domain. Government is whole, although there are three arms of government. So that provision, that in that term, in the putative agreement that the Minister of Labour spoke about, is the path to tread. But that does not determine or answer all the headaches that will come along the way. We have reservations about these provisions. Yes, I want the judiciary to be independent. I want the legislature to enjoy a degree of independence, but this should be done and worked out within a state. And they should be thought through logically. Once this so-called vote, or the amount standing to the credit of the judiciary, is given to the head of the judiciary of that state, the question that follows are as follows. One, would the judiciary then be the one to drop its budget in promotion of its own newfound financial autonomy and independence? So if it draws up its budget, will it self-approve its budget? If it doesn't self-approve the budget, will it then go back to the legislature that is run away from because it wants to be autonomous and independent to then say, pass the budget? In which case, judges will now be the one to go before the legislature to be defending their budget with all the attendant implications. Number 4, judges would they now have to have a tenders board in the judiciary for contract, for capital expenditure, awarding contracts and all that. And if that were to happen, what we see in the executive, where contracts are awarded and corruption follows, or in the legislature. So would that not happen in the judiciary? If it happens in the judiciary, are we therefore near that day when judges will now be going to the EFCC every day or ICPC in respect of the contract they have awarded and in respect of alleged kickbacks? I mean, these are the issues. And right now, enough anticipatory and proactive discussion that would deepen the debate. We're not having that. And that's a problem for me. So yes, the judiciary should be independent. The judiciary should have financial autonomy and all that. But really, it is not the province of judicial officers to now be awarding contract, spending money and all that. It may create other problems that could be worse than the one we intended to solve. That's my apprehension. And I hope that stakeholders will think through all this. Finally, we expect that using the state governors, all of them will come together and ensure that the judiciary is, because conspiracy theories can indeed allege that these executive people want the judiciary to die, and that they will not do anything so that, and all that. And some people have suggested that perhaps justice should have waited till an election petition period, when the politicians want to use the election petition. At that time, then they're back on strike. No election petition tribunal will sit, and so on and so forth. That's when you should really, really get them. But I think that fighting for justice is eternal. You can do it anytime. So it's not only when it is convenient that you do it. You also do it when it is inconvenient.
Away from that interview, the Lagos State Ministry of Justice has been speaking about its activities for the last 2 years. On Wednesday, the 19th of May, the Attorney General and Commissioner for Justice briefed members of the media. We have the details in this next report.
Our focus in the past 2 years in the Ministry of Justice is built around 5 parameters. One is to ensure that every resident of Lagos State has enhanced access to justice.
What has the state done as part of enhancing access to justice? Here's what the Attorney General had to say.
Right now, owing to the destruction of the Igbo Sharia High Court, we are providing alternatives. The Lagos State government sought and obtained the approval of the Attorney General of the Federation to convert the premises of the Ministry of Justice, Federal Ministry of Justice in Marina, as temporary courts to replace the Igbo Sharia courts that are destroyed and under construction, to putting it back. We have also, the Lagos State government also had at Osborne Foreshore Estate, a vacant property which has been converted to, I believe, 9 courtrooms, which will be ready by God's grace the end of May of this year. And so the judiciary, the judges, will be able to move in. And then also we have noted that part of the problems in the delay occasioned in the delivery of justice in our courts is the fact that all our courts virtually are writing down in longhand. So imagine, as I've been speaking, as everybody has been speaking, for all this to be captured all day by the judges. So, and we don't have to reinvent the wheel. International best practices, courts abroad use recording devices. So there is in place a contract. The first phase will deliver 10 digitalized courtrooms for the Lagos State Judiciary.
Technology will also play a big role in the administration of justice, and here's where the Justice Clock initiative comes in.
The Justice Clock is a case management application for the DPP's office. And from when they receive the file from the police, the clock starts to run. So they know that we have told the public that in 14 days, the DPP's advice will be out. So the clock starts running. The clock also doesn't stop after the legal advice is issued. It continues to run to show how long before trial was commenced, how long before trial was concluded. So that, and this process is electronic, so even if, as I'm sitting in this wonderful premises, I can look at my phone and see what is happening live in the DPP's office. One of the most important things we also did this morning was, we know a lot of, perhaps even a lot of the questions I'll receive today will be on delay in issuing the DPP's advice, legal advice. Why does it take time? Why is it not out? So from today, anybody who is arrested and his file sent to the Ministry of Justice can go to the Ministry of Justice website and inquire about the status of his or her legal advice. And you can get a certified true copy electronically without coming to Ministry of Justice in Alausa. This is very important because this is the first time in Nigeria that we are being 100% transparent with the process of the legal advice.
Apart from the courtrooms, the ministry is also partnering with the police and the correctional centers. This partnership has produced statement recording and interrogation rooms. Lagos is very focused on legislative reforms, and the Attorney General says it will constantly do more in this regard, especially because the government believes that this is one of the ways of ensuring that the state attains its goal of being a 21st century economy.
The very next day, Thursday, the 20th of May, the Attorney General welcomed the First Lady of Lagos and other key stakeholders in the state to the launch of the state's gender-based violence event virtual referral and response service.
Members of the State Executive Council,
in partnership with the European Union-funded Spotlight Initiative, Women's Helping Hands Initiative, and with technical support from the United Nations Population Fund, the UNFPA, the Lagos State Domestic and Sexual Violence Response Team officially launched its 24/7 toll-free helpline to rapidly respond to survivors of sexual and gender-based violence.
The fifth Sustainable Development Goal of achieving gender equality and women's empowerment is a standalone goal under the Sustainable Development Goals, but it is also an intrinsic part of all the other Sustainable Development Goals. If we do not deliver on SDG 5, we will not be able to deliver the Sustainable Development Goals. Providing access to gender-based violence services enables us to fulfill the SDG principle of leaving no one behind, which the United Nations is very committed to.
Leaving no one behind is indeed key, and one after the other, key stakeholders speak to the rationale behind this launch.
during the COVID-19 pandemic, the Lagos State Domestic and Sexual Violence Response Team, DSVLT, reported an increase of 35% of domestic and sexual violence cases via our hotline and social media handles. The barriers to services amidst the documented rise in the sexual and gender-based violence incidents during the COVID-19 pandemic necessitated the quick adaptation of sexual and gender-based violence case management service delivery models by exploring innovations to reach people with services during the pandemic and even beyond. This birthed the Lagos State Gender-Based Violence Virtual Referral and Response Service in 2020.
The AG speaks to the figures and reports received by the state's Domestic and Sexual Violence Response Team. He assures Lagosians that the government will always protect its most vulnerable, even as he reaffirms the government's stance on zero tolerance for gender-based violence.
Since the introduction of the state's toll-free line in July 2020 to date, the team has recorded steady increase in reporting. Over 2,450 cases have been handled during this period, and the highest reporting of cases emanated from Alimosho, Ikorodu, Ifako, Ijaye, and Koshofe local governments. Whilst we are encouraged by the increase in reporting, we however know that we have not yet scratched the surface. By virtue of the GBV VRRS, which we are formally launching today, callers will be able to access the following services: clinical management of rape, psychosocial support, security and access to justice. These services will be delivered at no cost to the clients, whilst maintaining the principles of survivor-centered approach, safety and confidentiality.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shala Shieli. Thank you for watching and see you next week.